Great. Hello, everyone. Welcome. My name is Janice, and I'm the managing attorney of the Low Income Taxpayer Clinic here at Maryland Volunteer Lawyer Service. We want to thank everyone for joining us. We have a wonderful speaker today, and we're just going to go ahead and get started. The first slide just shows you a little bit about us, MVLS, and how to follow us on social media. And then Jennifer, if you'll advance to the next slide, please. Great. This is some information about our website and resources for MVLS volunteers. If you are not already on our volunteer panel, we certainly invite you to join us. We have available attorney resources where we'll also have this webinar as well as the slides placed on there so you can re-access it in the future. And also available cases where you can practice what you've learned today. So Jennifer, if you'll please advance to the next slide. And I also want to highlight our Judicare opportunities. This is a reduced fee program that where you can actually get paid. And if you're interested in it, typically I think you do have to have had several years of experience in order to do this. But if you have any interest, please call Michelle Swift, our pro bono coordinator, at the number that's on the slide. So I'm going to let Jennifer go ahead and start. Thank you so much, Jennifer, for joining us. Jennifer is here's some information about our upcoming trainings. And then next slide, please. Great. Thank you, Jennifer.
Thank you. So my name is Jennifer Lubinski. I have been practicing for about 20 years. I started out practicing doing business and commercial and insurance litigation. I still do a great deal of that, as well as employment litigation. But very soon after I had been admitted to the bar, I personally found it frustrating that I didn't get the opportunity to sort of deal directly with people, and I wanted to be able to do more of that. So I signed up for a training with MVLS on family law cases. And that was really my first exposure to the family law arena. I didn't take the class in law school. And I have been doing MVLS family law cases ever since. And when I opened up my own practice a few years ago, I started doing family law more broadly. But the purpose of this seminar today, I was hoping to just sort of take you through the stages of a family law case from start to finish. You can spend 10 hours and more talking about family law cases and litigation, custody litigation, things that concern assets, tax issues, and that's sort of beyond the scope of what I can talk about today. So I want to talk about kind of what the stages of a case are and what you can expect when a client comes to you with a brand new family law matter.
And Jennifer, I'm sorry. I just wanted to mention, I forgot to mention earlier that if anyone does have questions, to please put them into the question box. If you could please type them into the question box that's on your screen. We're going to try to hold all questions till the end, just so that we don't interrupt the flow of the presentation. Thanks, Jennifer.
Sure. So when someone calls you and they have a family law matter and it's not already in court, and you will get those calls too. You'll get calls where people have a trial in 2 weeks and they need to get a lawyer involved. But if they call you and really they're still in the very early stages of a case, there are a number of things that you will want to discuss with your potential client before any sort of lawsuit or claim is filed. One of those is whether or not the parties have any other agreements. Many times people, particularly nowadays, are mediating cases with private mediators before they ever talk to lawyers. And they may have a mediated written agreement and they realistically just need you to help them with a couple of issues, or they just need you to help them get a divorce. So you want to know about any agreements that they have, and that may be a formal mediated agreement that covers everything from A to Z. It might be a piece of paper that someone sat down at the kitchen table and said, all right, I'm going to have the kids on Mondays, you're going to have the kids on Wednesdays. That realistically may well be enforceable. You also want to ask people about any pre-existing orders. People don't always understand sometimes because this is the family law arena and relationships have ups and downs. And you may have a couple who 3 years ago, someone went and got a custody order, and they may have abided by that custody order for a time, and then maybe everybody got back together and has been living together since, and now they're breaking up again. And the question that they're just assuming that that order that was entered 3 years ago doesn't matter, but it probably does. And you need to know about it, if only because if that's an order that's applicable, you're going to be filing potentially to modify that order as opposed to filing a brand new custody case. You're going to want to talk to your client about whether your client has any other alimony or support obligations. Was there a previous marriage, and are they paying alimony to a previous wife? Are they paying child support to other children? Because those factors will be considered in figuring out what a child support obligation is in this case if there are children. You're going to want to talk to your client about whether or not it makes sense to try and get the case settled at an earlier stage, and it almost always does from a financial perspective. But settlement at an early stage in family law cases will often depend on how well the parties are working well together or are working together. They may be completely amicable. They sort of know what they want to see happen here. Everyone's on the same page. And those are the easy ones. Pray for those to come into your door. But very often when they come to you, people are angry. Someone has walked out, said that they've got a boyfriend or a girlfriend and they're moving on, and the other party is really angry about it. Or someone has taken some money out of an account that the other party thinks they shouldn't have taken. And people's feelings are going to be motivating what it is that they do in this case. And the more emotional they are, the more difficult it's going to be to get to settlement at an early stage. You may very well be able to settle the case at a later stage after people have gotten through some of the things in litigation like discovery and emotions have cooled. But you want to talk to people about that beforehand because you want them to understand what it is that they're getting into. If realistically they want to litigate this, they want scorched earth litigation, and so many people will come into your office and tell you that's what they want to do. You want them to understand that's great. You are happy to do that, or you may not be happy to do it, but you were willing to take on that kind of strategy, but it's going to cost them 25 grand. And oftentimes that will change the way that they're looking about how this case is going to proceed. And then obviously you're going to want to talk to your client about what your fee arrangement is going to be. Many attorneys these days are taking cases on a flat fee basis. In cases where it's unclear how much is going to need to be litigated, you're probably going to want to take that on an hourly rate basis with a retainer of some kind. If you're taking a case through MVLS, as I certainly hope that you will, then you're not going to be collecting a fee, or unless you're taking it through Judicare, in which case you'll be collecting a fee through MVLS, but you will probably want to have an engagement agreement with your client that sets forth what your obligations are, what the client's obligations are. And one of the most important things you're going to want to have in such an agreement is that your client needs to stay in touch with you, because that really can be an issue sometimes in cases that you get from MVLS. People will move and they won't tell you. And not everyone has an email address. Sometimes cell phones get turned off. So you've got to really stress to your client how important it is that they maintain in contact with you going forward so that you can reach them if something comes up. Religious considerations, you may want to discuss at an early stage. People who are Jewish, for example, and observant may want to proceed before something called the Beis Din or the Beit Din, which is a religious court that is designed to deal with these issues. And religious Jewish people will want to receive a get, which is a religious divorce that permits them to get remarried. For Catholic people, they may want to receive an annulment that will allow them to get remarried. So you're going to want to know, are those considerations that your client has? And then I ask my clients for that first meeting to bring in essentially any documents they can think of that are going to be relevant, but those are going to include their pay stubs, tax returns going back a few years so that you can look at what the party's income has been. Sometimes the other party will say, look, I'm only making $25,000 a year, but if you get the tax returns going back a few years, you'll see that previously he's been making $75,000 or $100,000. And you may need to find out why it is that suddenly he's making so much less. It may be for a perfectly valid reason, or it may be because someone doesn't want to pay child support. You want to know that. Your client is going to have to fill out for you a financial statement. You can find a copy of those forms on the Maryland Judiciary website. There is a short form financial statement, which you can use in cases where the only issues are child support, and that really just shows what the parties are earning and what certain child-related expenses may be, including health insurance. A long-form financial statement is going to be required in any case where you're requesting other kinds of relief, such as alimony. I ask my clients as a rule to prepare the long-form statement simply because it's useful to have that kind of information. You may wind up only filing the short-form financial statement if that's all you need to file, and you don't necessarily want to tell the other party everything that's on the long form. But it's useful to have the information on the long form in your file. If there are minor children at issue, and obviously that's something that you're going to discuss with your client when you're talking to them about what the issues in this case are going to be. You're going to want to assemble documents that are going to be relevant to the best interests analysis, and those may be things like photos of the children, the children's drawings, particularly if they're younger, their report cards, things along those lines that you can use to show the court sort of how well these children are doing. Sometimes you will have a client who comes to you with someone's medical records. That may be a child's medical records. Generally speaking, a parent is entitled to their children's medical records, but you still want to treat those records with caution and respect. And treat those as you would any other piece of confidential information that comes into your office. The more troublesome situation is when a client comes to you with their spouse's medical records. And that often happens when you have a client who believes that their spouse has a mental illness of some kind, and they will bring to you the client's therapy records or records of a mental health hospitalization, and you are not entitled to those records. And realistically, probably your client is either. So you're going to want to treat that situation very carefully. I don't accept those medical records. I don't look at them. If I am concerned that that if I give them back to my client, those records are going to disappear or go someplace else, then oftentimes what I will do is I will put them into a sealed envelope. And if the other side is represented by counsel, I will forward those records to counsel. But you need to be familiar, even though you're doing family law, you need to be familiar with HIPAA and with Maryland's statute on the confidentiality of medical records, because that does come up in the context of family law cases. And the last thing that you want to do, because I have seen it happen, is for your client to whip out somebody's hospital record in the middle of a trial, wanting to show the judge, look, I can prove he's crazy. And the judge will be very, very upset when that happens. So assuming that your client is prepared to move forward, the next thing is, you may be able to negotiate an agreement with the other side. And if you can do that, then oftentimes what you are simply doing is filing a complaint for a divorce and attaching a copy of that agreement, and then going to court and putting simple testimony on the record that establishes the grounds for divorce, and that incorporates the agreement into the divorce decree, and then that's it. Those are the best case scenarios. If issues cannot be resolved, you may be able to resolve some of them and draft an agreement on some of those issues, and you may only have to litigate others, or you may have to litigate everything. In either case, that begins by filing a complaint, either for limited or for absolute divorce. You're going to want to familiarize yourself with the grounds for divorce that are set forth in the Family Law Statute 7-103. The most usually used grounds is the voluntary separation ground, where the parties simply voluntarily have been living separate apart for a year at the time of filing. And that will entitle you to an absolute divorce, which is a divorce that severs the marriage relationship entirely. You may also file for a limited divorce. Oftentimes people will come to you and say that they want a legal separation, and usually what they're talking about is a limited divorce, which means the marriage is not severed, and you don't have to have a full year of separation. You know, as soon as you separate, you can file for a limited divorce. The court can get involved and can make decisions with respect to custody and visitation and support, but the marriage remains. And until you have a basis for an absolute divorce, it will go on remaining. Oftentimes what people do, if it's, you know, a highly contested case, is they will file for a limited divorce as soon as they have a separation so that they can get some of those issues dealt with quickly, particularly if there are children at issue. And then once the case, the parties have been separated for a full 1 year, you can file an amended complaint, changing your ground to, or changing your request to one for absolute divorce, and the court will proceed on that basis. There is also a new part of that statute, relatively recent, which permits divorces by mutual consent. And those are for parties who do not have any minor children, who have entered into an agreement that resolves all issues. So you can't have any outstanding issues on property or anything along those lines. Both parties must appear in court. And so long as you can do that, then you can receive a divorce based on both parties' consent. You may also file a case for parties who have never been married for custody or support only. So the fact that the parties haven't been married doesn't mean that you won't be handling a family law case for them. There is a domestic information report that needs to be filed with your complaint that will set forth, you know, certain information. You'll be checking off what kinds of relief it is that you're requesting from the court, particularly if you want the court to meet with the child, or if you want certain kinds of relief like a best interest attorney appointed. You'll be checking that off on your information report. And then I wanted to talk a little bit here about service issues, just very briefly. I'm sure you're familiar with how it is that you serve parties with pleadings. Generally speaking, a divorce complaint is served the same way you serve any other complaint, either by private process, by the sheriff if that's appropriate, by certified mail if that's appropriate. Be familiar with the requirements for each of those. Occasionally, parties will come to you who have been, you know, or a party will come to you who has been separated from her spouse for 20 years or 10 years and will have no idea where they are. And those are tricky, because that person is obviously entitled to a divorce, but it's difficult to find the spouse to serve. You will be permitted generally to serve that party, the missing party, by substitute service, which is usually publication. But you're going to have to jump through a lot of hoops first with the court and showing the court what efforts you have made to locate the party and to have him or her served. In terms of when you can file your complaint in Maryland, you're going to need to plead that the parties have been, or a party has been, a resident in Maryland for at least a year, or that the grounds for your divorce occurred in the state. So if there was, if this is a fault-based ground and adultery occurred in the state, you may be able to base your complaint on that. The defendant does not have to be in the state, so long as you have either of those grounds. The venue where you file your divorce is going to be where either party lives, where the defendant works, where the child lives, if there's a minor child at issue. And note also that your complaint can only be filed once your ground is actually ripe or in existence. So for example, parties will sometimes come to you who are living in the same house and they want to file for divorce, and they will tell you, look, he lives upstairs, I live down in the basement, we're completely separated. Can you file for a limited divorce or some sort of divorce on that basis? And my answer to that question is maybe. And to some extent, it depends on the court that you're in and how disputed this case is. The more disputed it is, the less likely the court is likely to permit you to proceed on that basis. What I tell people in that situation is, if you want a divorce, sooner or later, one of you is going to have to move out, realistically, and you are more likely to get the result that you want if someone moves out. Just like in any other case, once the complaint is filed and the other side has been served, the other side has to file an answer. Talk a little bit about default, because that's something that comes up with some frequency, and particularly in MVLS family law cases. You may get your other side served, and then when that party does not file a response within 30 days if he's in state, or 60 days if he's out of state, then you will ask the court to enter an order of default, and you'll have to set forth how it is that you serve the defendant. And in the family law court, particularly in Baltimore City, getting a default entered requires certain kinds of information. I think they are now requesting an affidavit from the plaintiff, him or herself, that says that he or she knows that the defendant received this complaint. So familiarize yourself with what's going to be required in the court before which you're practicing. But also understand that, generally speaking, if you get a default judgment in a case that involves minor children, that default judgment will not preclude the other side from participating later on with respect to custody and support issues. The court just simply isn't going to decide custody matters on a default basis if the other side later appears and wants to participate. Property issues, potentially, but not custody matters. In responding to the complaint that's filed, there are certain issues that you must raise preliminarily by motion to dismiss if you want to raise them. Those are venue, insufficiency of service of process, or personal jurisdiction. An out-of-state defendant, for what it's worth, cannot challenge the venue that the in-state defendant or the in-state plaintiff has chosen. There are also other matters that may be raised by preliminary motion that would include subject matter jurisdiction. For example, if the court does not have jurisdiction because a party has not, in fact, lived in the state for a year before filing and grounds did not occur in the state, that can be raised at any time, even after filing an answer. Your answer, in addition to having to admit or deny each factual allegation, must set forth any affirmative defenses that you have. For example, in an adultery case, there may be a condonation affirmative defense. Counterclaim practice. Oh, and I should also note, if you can plead alternative grounds. So your case can be pled with respect to separation, and in the alternative with respect to desertion, you can plead all of these grounds in the alternative. Counterclaim practice is not compulsory. Any counterclaim that the other party may have is not required to be made by way of counterclaim to the complaint that's been filed, and a separate suit can be filed, but in most cases that doesn't make any sense. In most cases it makes sense to proceed by way of counterclaim. And any allegation that is not either answered or denied in a complaint is going to be considered admitted. So you should be very careful in terms of responding to the allegations that are made in the complaint. Note also that in a case where there are minor children and child support is being sought, the court will be able to award child support dating back to the date that the complaint is filed. So if you have a party who is refusing to pay support for whatever reason, that's often one of those cases that you want to get the complaint filed sooner rather than later, so that, to the extent that there's going to be any back child support awarded at the time of trial, it'll go back to the time of filing of the complaint. You're going to want to be familiar with Family Law 9.5-201. which sets forth certain requirements that must be pled by both parties with respect to any minor children. in terms of whether or not the parties know of any other orders involving the children, any other parties who have claims of custody with respect to the children. And I wanted to talk just very briefly also about the concepts of bifurcation and reservation. Family law cases can be bifurcated, which means that you can ask the court to hear only certain issues initially and reserve the rest of the issues to be decided at a later time. And when that often happens for tax purposes, if the parties would really like to get a divorce in a particular year so that the next year they don't have to file for taxes jointly, they can get a divorce that year and reserve other issues such as property award, marital award for determination at another time. Keep in mind that if you do obtain a divorce and you have failed to reserve your right to request a monetary award, your right to obtain a monetary award will effectively lapse 90 days from the date that the court enters its divorce decree. So if you are going to bifurcate, make sure that you have very carefully reserved your right to proceed with respect to any other kinds of relief that you are requesting. The next stage, typically once you have filed a complaint and the complaint has been answered, is for the court to either hold a scheduling conference, some courts do that, or to simply issue a scheduling order. So you're going to want to be familiar with Maryland Rules 2-504 and 2-504.1 in terms of what happens at the scheduling conference. Keep in mind that some of the issues that will be dealt with at a scheduling conference will include any electronically stored information, and that may be things like emails, information that may be stored on the parties' phones, and that is a very hot issue for family law these days, particularly in a case that may involve an allegation of either abuse of a child or of adultery, because very often people are, they're sending photos on their phones, they have dating apps on their phones, they're texting on their phones, and it is next to impossible to get that kind of information from the phone service provider, even via subpoena. So you're going to want to the extent that you want information from someone's phone, you're going to want to ensure, number one, that they're aware of the obligation to preserve that evidence going forward. And then you're going to want to talk to opposing counsel, hopefully you have opposing counsel involved in a case like this, about how to make arrangements to get that data. Other kinds of interventions or relief that you may be requesting at a scheduling conference, whether or not you want the court to appoint any neutral experts, like a child custody evaluator, a best interest attorney, which I'm going to talk about in a little bit, whether or not pendente lite relief is being requested. And keep in mind also, and that again, this practice will sort of depend on what court you're in, but in many of the court systems, when you appear for a scheduling conference, if there are unsettled custody and visitation issues, the court will try to facilitate some kind of interim visitation arrangement, either through a magistrate or through like a court facilitator, so that the parties aren't waiting 6 months for a PL hearing to get those issues resolved. The parties won't always be able to get it resolved that way, but the court will try. And so you should counsel your client in cases like that to expect to be sitting down with somebody to talk about potentially some sort of visitation agreement. Another thing that you should keep in mind is in cases where there are allegations of mental health issues, particularly in custody cases, you do have the right under the discovery rules to file a motion for a request for a mental or physical examination. You would do that under the discovery rule 2-423. You know, in personal injury cases, we do stuff like that all the time. People get sent out for IMEs. In family law cases, the process is the same. It doesn't happen as often. IMEs or evaluations are going to be expensive. You know, your party is going to be asked to pay probably $1,500 or more to have an evaluation like that covered. But in an appropriate case, that tool is really, really valuable to the extent that you want the court to order that sort of relief, my practice is to file that motion at the same time that I file the complaint so that we can deal with it at any scheduling conference. I want to talk now briefly about pendente lite hearings. A pendente lite hearing will be held in a case where there are custody and support issues, or there's a family home and children, and there are questions in terms of who gets to use the family home. And it's meant to be an interim order. It's meant to basically tide everyone over until the court gets to a merits hearing. Having said all of that, because we are dealing with minor children, realistically, the PL hearing is going to be the hearing that decides what happens going forward, because unless there is a really good basis for disturbing that arrangement after a merits hearing, the court is unlikely to change it. The children will have settled in. They will have gotten used to a particular schedule. They will have settled into the house if they've been awarded use and possession of the house. And, unless something pretty unusual happens at an eventual merits hearing, it's very unlikely that the court is going to go back and change its mind about the PL relief that it granted. So you're going to want to prepare for a PL hearing just like you are preparing for a trial on custody, because that's where these issues are going to be decided. You should request any pendente lite relief in your complaint and make sure you point out at any scheduling conference that there is a request for PL relief pending, because typically the court will choose a date for the PL conference at your scheduling conference. The kinds of relief that are available by way of PL order include, as I just said, use and possession of a marital house, custody of the children and visitation, support. Keep in mind that use and possession may involve a rental property. I think people don't always understand that. So if the parties are living in an apartment and they are separating and one spouse wants to be able to remain in the apartment with the children, the court can order that. And the court may also award use and possession of certain personal property like an automobile. Property that is acquired after the parties separate is not subject to a use and possession order. So if after the parties separate, someone goes out and buys a vehicle, that vehicle is not going to be subject to a use and possession order at a PL hearing. Keep in mind, again, if you are requesting an award of child support, you're going to want to be familiar with the Maryland Child Support Guidelines. Those are presumed valid. Getting a court to deviate from the guidelines, except in cases where you're asking the court to award more money as opposed to less money, is extremely difficult. Practically speaking, familiarize yourself with a program called SASI-Calc. It's SASI/CALC. That is the support calculator that essentially courts use. Everyone who practices in this field generally uses that. It's software. You plug in numbers and the names of children, and it will generate a child support worksheet for you. You can do it by way of the tables that are available for free on the judiciary website, but you will find that the numbers you get that way will differ from the ones that you calculate using SASI-Calc, and you're going to want to use SASI-Calc. Just note that in cases that involve children, custody and support, those cases are generally going to be heard by a magistrate as opposed to by a judge. Talk a little bit about discovery. The methods that are available for discovery in a family law case are the same discovery methods available in any civil case. So interrogatories, requests for production of documents, requests for admissions, again, request for a mental or physical exam. Although again, that's requesting a mental or physical exam is something you're going to want to reserve for the very unusual case where you have a party who is showing definitely signs of some sort of mental illness. If you request relief like that in a case where it's just two parties who can't get along and don't agree who's going to be the better parent, it's unlikely that the court will award that. Again, when you serve your discovery request will to some extent depend on what the practice is in the court where you are proceeding. Certain courts prefer that you not issue your discovery request until the court has issued a scheduling order, and the scheduling order will in fact set forth a schedule for service of discovery requests. For example, interrogatories must be served by such and such date. All discovery generally must be completed by such and such date. But in my practice, unless I have a reason not to, my practice is to serve discovery requests at the time that I serve the complaint. And then obviously you know that the time for responding to outstanding discovery requests is within 30 days of service. Be very careful of requests for admission, because if you fail to respond to those within 30 days, then the information that is sought will be deemed admitted. You can take depositions of parties and third parties just as you can in any other civil case. Expert witness practice. There is a role for expert witnesses in these cases. There are many roles for expert witnesses in these cases. There may be a financial expert, someone like an accountant, someone like an actuary, if there are issues with respect to pensions or 401ks. There may be someone who is there to testify about tracing funds if one party has received an inheritance and wants to take the position that those funds are non-marital. An expert witness may be brought in to testify sort of what happened to those funds. Just as frequently, expert witnesses may be brought in to testify with respect to custody issues, and they may include people like psychiatrists, therapists, social workers, people who have contacts either with the parties or with a child, and who are being asked to testify in terms of, the fitness of the parties to be parents, with respect to the effect that the parties' separation may be having with the children, and so on and so forth. Experts are expensive, and to the extent that your client is interested in designating an expert witness, they need to understand that it's going to cost them, $1,500 to $2,000 or more, depending on the expert witness. So that's something that's a conversation that you will want to have with them at an early stage of your representation. And then you're going to proceed with expert witness discovery just as you would in any civil case. Expert witnesses are not treating physicians, although treating physicians occasionally may be called as expert witnesses. The kinds of experts that I'm talking about are not treating. They've been brought in strictly to consult, to prepare a report and an evaluation. And that is not a treating physician relationship, and therefore there is no healthcare provider privilege that attaches. And in fact, the physician or the expert will tell the person that they are seeing at the outset that this information is not going to be privileged, that at the end of the day they're going to prepare a report of their findings. You can request an award of expert witness fees at an early stage of the case, particularly at the pendente lite hearing. If you believe that you're going to be calling expert witnesses and that you will be requesting an award of fees, that's something to be brought up with the court at the scheduling conference, and probably to be pled in your complaint. Now, if the parties have not attempted mediation before filing suit, they will often be mediating these issues either as they are completing their discovery or once they have completed their discovery. You're going to want to be familiar with the practices of the particular court that you're practicing in terms of ADR. Some courts issue a mediation order at the same time that they issue the scheduling order. Other courts wait until after there's been an initial conference, and they sort of want to hear from the parties in terms of whether or not mediation would be helpful and what the issues would be. The court will generally order mediation wherever there are children involved. If it's strictly a property thing, the court will not generally order mediation, although the parties are always free to mediate if they wish to, or to request mediation if they wish to. Additionally, the court will not order mediation if there is a genuine issue of abuse of either one of the parties or of a child. On that, the civil domestic case information report that you fill out at the outset of the litigation, you will see that there is a box to check if there is an issue of abuse. But also that's something that you will want to bring up with the magistrate or the judge at your scheduling conference to make sure they're aware of that before a mediation order is issued. I'm assuming that you're familiar kind of with how mediation works, but generally speaking, mediation is a process whereby the parties sit down with a neutral, and the neutral tries to facilitate an agreement. The neutral doesn't decide the case. The neutral doesn't tell anyone what they ought to do. The neutral simply just talks to each side and looks for ways that the two of them can come up with an agreement. In addition to that kind of private mediation, one of the sort of hot areas of practice right now is with respect to parenting plans. And courts are likely to begin requiring parenting plans in disputed custody cases going forward. And a parenting plan is a little bit like a piece of a settlement agreement or separation agreement where the parties decide, who's going to have what child at what time and what kind of contact will be allowed, with the children, phone contact with the other parent, all of those issues. Who will be responsible for providing transportation? Who will be taking the child to concerts or sports activities? The impetus here is to try and get people thinking about these issues at an early stage and getting them down on paper so that there's no confusion and so that the children, frankly, aren't being kind of dragged through a difficult, litigious process along the way. And as far as court-ordered mediation goes, the court, in certain cases, will waive the fees, particularly in an MVLS case. Depending on, again, the court that you're in, Baltimore City uses volunteer attorneys who come in and mediate these cases. But in counties where attorney mediators are appointed and there are fees to pay those attorney mediators, if you move the court to waive those fees, and particularly if you're representing an MVLS client, the court will generally waive those fees. And in fact, I think in order to be appointed to the court-appointed attorney or mediator roster, people have to indicate a willingness to receive pro bono mediations from time to time. Another kind of, I put this under sort of ADR, even though it isn't technically ADR, but one of the things that a court can do is to order a custody evaluation. That can be granted either on mutual request of the parties. So if both parties at the scheduling order say that they want to have a custody evaluation, the court will order it, or on one request or the request of one party, the court may order it as well. A custody evaluation will typically be conducted by a social worker of some kind. There's no privilege that attaches to those interactions. The custody evaluator will meet typically with the minor children and with both parents, and then prepare a report of his or her findings to present to the court. Generally, a party is not obligated to turn over any mental health care records to the custody evaluator. But if they do turn those mental health care records over, then the other party is entitled to see a copy of them. Once the report is prepared, both parties have access to the report. It will typically be kept in a confidential section of the court file so that random people who may want to come in and look at court files for whatever reason are not going to be able to see the custody evaluation. And then the parties who have been interviewed, the parents who have been interviewed as part of this custody evaluation, must be given an opportunity to cross-examine the custody evaluator at any merits hearing. Arbitrations do occur in the family law context, often in the religious divorce context, but you should be aware that while an arbitration concerning property will generally be enforced in the circuit court if necessary. And arbitration concerning children will not be enforced. The court always maintains the power and the authority to determine what's in the best interest of the children ultimately, and the court will not consider itself bound by any arbitrated determination with respect to that. Substance abuse evaluations is a form of relief that may be requested, again, at an early stage of the case, usually at the scheduling order or the scheduling conference. You're going to want to be able to explain to the court your basis for believing that the other party may be abusing substances, and your client should be prepared for the fact that he or she will be ordered to take a test himself or herself as well. And also understand, that in this day and age, telling the court that your spouse smokes weed on the weekends when the kids aren't at home is not something that's either going to shock the court particularly or that is going to be considered particularly relevant in making a custody determination. What the court is going to be looking at is whether or not there's evidence of bad judgment. In other words, using substances in front of the children, driving the children places while under the influence of some kind of substance, whether or not that party is engaged in, difficult or outrageous behaviors while under the influence of substances. And then obviously the more sort of scary, for want of a better word, the substance itself is, the more likely it is that the court's going to be bothered by it. So, weed is one thing, realistically, at this day and age. PCP is another. If you've got some evidence that the spouse uses PCP on a regular basis, the court's far more likely to award a substance abuse evaluation in that situation. And then again, court-appointed psychiatric and social work evaluations may be ordered where there's some evidence of either mental health issue in one party, or where there are issues in terms of whether or not a party is able to adequately care for children. And the social worker may come out and do a home study and look around, sort of see where the children are sleeping, see what kind of living conditions are present, get a sense for whether or not this is a stable, safe environment for the children, and report back to the court on that issue. One more topic I wanted to cover real quickly is collaborative law, which again is a growing area of practice. Parties who are splitting up on a fairly amicable basis will often attempt or will approach collaborative practitioners who are attorneys who are specially trained. You have to have a collaborative practice certificate, and those attorneys are retained only for negotiation and mediation purposes. And in fact, if the discussions break down and the parties decide that they are going to move to litigation, they cannot do that represented by the same attorneys. They have to fire the collaborative attorneys and retain new attorneys. In cases involving minor children, the court has the power to appoint a best interest attorney. You're going to want to familiarize yourself with Family Law 1-202, which is the statute that has to do with appointment of counsel for a minor or a best interest attorney or a child advocate, and those are three different roles. Generally speaking, counsel for a minor is just that. They're an attorney. They represent the minor. They're there to advise the court of what the minor's preferences and desires may be. A best interest attorney is there to report to the court about what the child's best interests are, and those may include the child's preferences, but they're not limited by what the child's preferences are. And then an attorney may be appointed, a Nagel versus Hooks attorney may be appointed to determine whether or not to waive the child's privilege with respect to any healthcare treatment that may be relevant for whatever reason. Any order that's appointing an attorney for a child is to specify the role for which the attorney is being appointed. There are practice standards set forth for these kinds of attorneys in Maryland Rule 9-205.1. They're very detailed practice standards in terms of what these attorneys should be doing depending on the role for which they are appointed. And attorneys who are appointed to these positions are generally entitled to compensation. And the court, at the time that they are appointed, will specify how they are to be compensated, whether the parties are to share the fees, whether there's to be a retainer of fees set aside. That will be sort of determined by the court at the time of the appointment. The next stage in your litigation, once you have worked your way through your PL hearing, if you have one, your discovery, will be a pretrial conference. And again, the practice varies by city or county. Baltimore City holds a robust pretrial conference in disputed family law cases, and you should attend your pretrial conference prepared to discuss what your exhibits are going to be, which witnesses you're going to call, and essentially to be prepared to go to try your case. Be familiar with the information that is required to be provided in the pretrial statement. That's Maryland Rule 2-504.2. And then, again, depending on which court you're in, you will typically receive your trial date maybe 30 or 60 days after your pretrial conference. Courts, and particularly in Baltimore City, are becoming very strict about requiring the submission of the Joint Statement of Marital Property form, which you can find listed on the Maryland Judiciary Court Form website. And that is to be filled out by both parties, and essentially the parties fill in what all of the items of property are, and then they state what each party's position is in terms of whether that's marital property or non-marital property. And the court uses that form in terms of deciding what to do with the marital property. When you are trying a case like this, the best thing that you can do is to be well prepared for your trial. And that means to have your exhibits assembled and copied and organized so that you're not digging through piles of paper at counsel table. I generally try to pre-mark my exhibits, and that means that I have gone through and prepared my witness examination, because I need to know when I'm planning on using my exhibits so that I can mark them in some sort of reasonable order. You will want to have spoken with the other side to the extent that they are represented about any stipulations that you can enter into. Courts very much appreciate that. If you can limit the issues that the courts have to decide, if you can stipulate as to certain things like the date of separation and so forth. You will want to have prepared your witness list, know who it is that you're planning to call, and any other housekeeping issues. So, for example, if there are going to be people who can only be present on particular days because of work schedules, those are all things to bring up with the court at the pretrial conference so that the court can plan accordingly. If you arrive for court on the day of your trial and tell the court that, you know, the witness that you were planning to start with can't be there for another 4 hours, the court is probably going to be pretty impatient with you and is going to expect you to call someone else and keep the case moving. I want to talk briefly about meetings with minor children, meetings between the court and the minor children. Courts can do this. They hate to do it. They very much prefer not to be asked to do it, but they do have the authority to do it. And particularly in cases where children are a little bit older, like around 14 or 15, and they may have some preference in terms of visitation or custody, you can ask the court to meet with the child or children and to talk to them about those issues. There are all sorts of written and unwritten rules in terms of how those meetings proceed, and you will want to familiarize yourself with that. There is a line of cases that has to do with meetings between court and the minor children. Those meetings take place outside of the presence of the parents, but they are recorded. And oftentimes the parents will agree on a list of questions that is to be asked the children by the court. And then after that meeting, the court will report to the parents about what the children have said, so that the parents, as the case may proceed further, can address those issues via other testimony or evidence if they want to rebut something that's been said. Again, courts really, really hate doing these meetings. They don't like the children being put in the position of having to, or feeling like they have to advocate for one parent or another, or feeling like they have to protect a parent. So you're more likely to get a meeting in a case like this for a child if the child is a little bit older, and if there seems to be a good reason for the child to have a preference, such as where one parent is planning a move to someplace significantly farther away that would take the child away from his or her friends or school or something along those lines. Again, and additionally, the role of the best interest attorney is to some extent intended to alleviate the need for those kinds of meetings, because the best interest attorney will typically be representing the children and communicating to the court about what the children may prefer. And, you know, if there's something like a contemplated move, how the children feel about that contemplated move. In family law cases, many hearings or determinations are made initially by magistrate judges. Magistrate judges often handle the PL hearing. They may handle the merits trial. And at the conclusion of that proceeding, the magistrate judge will prepare a report and recommendation, which goes to a judge. And to the extent that either party disagrees with the magistrate's report and recommendation, they must file exceptions within 30 days of receiving the report. And exceptions become essentially a mini appeal. Once exceptions are filed, you will then be given a hearing before a judge, and you will, you know, argue to the judge about why the magistrate's findings or rulings here are inappropriate. It will be sort of a mixed hearing based on factual evidence and arguments of law, typically. And then the judge will enter a decision either affirming the magistrate or not. You know, the tendency here is to affirm the magistrate unless there is some fairly clear deviation from either standards of practice or the rule of law, or if there were evidentiary rulings that were made that were just clearly incorrect, and certain evidence either was received and should not have been, or was not received and should have been. The judge is very often going to approve what the magistrate recommends. Just very briefly about motions practice in family law cases. People do and can file motions for summary judgment. Those will typically be treated more seriously when you're dealing with financial issues, such as you know, whether or not a particular piece of property is marital or not, or whether or not assets in a particular account are traceable to an inheritance or not. Generally speaking, a summary judgment motion, particularly in a case involving contested custody issues, is not going to be granted. The court's going to hold a merits trial on those issues. The other kind of motions practice, which you will find useful in these kinds of cases, is motions in limine, where you ask the court to rule in advance on the admissibility or non-admissibility of a particular piece of evidence. And the court is actually generally pretty favorable to those kinds of motions because it permits the court to make a ruling at an early stage. Although keep in mind that, you know, one of the great values of motions in limine is to keep objectionable kinds of evidence out of the hearing of a jury. And, you know, this is a family law case, so there is no jury. But so you will want to consider sort of whether there are particular discrete evidentiary issues that you will want the court to rule on the admissibility of those issues in advance, either because it means having a witness there or not having a witness there at an eventual trial. And then finally, after you have held your merits hearing, eventually the court after considering all of the evidence that is received, will enter a judgment. And if this is a divorce case, a divorce decree. The judgment may include references to all the sorts of relief that you have requested, whether that be child support, use and possession of the marital home, whether or not there's to be a quadro for any pensions or 401k accounts, alimony, counsel fees, which may have been requested if this is an alimony or a child support case. If there's been a marital property award, that will be reduced to judgment in the court's judgment of divorce. Once that judgment has been entered, you have the same right of appeal of that judgment as you do in any other civil case. A notice of appeal would have to be filed within 30 days from the date of the order. Other than filing an appeal of the court's actual judgment, there's other kinds of post-judgment practice which may be appropriate. You will typically, the parties will often file any quadro that needs to be prepared after the court has entered its judgment. And you will want to make sure that the court, in its judgment or decree, leaves the case open for that purpose, if that's what the plan is, to file a quadro. If the judgment calls for the parties to do certain things, like to pay a certain amount of money from one party to the other, or if the judgment contains provisions on custody and visitation, which a party then fails to follow, the court's judgment in family law cases is enforceable by contempt. And in order to initiate a contempt proceeding, a party will file a request for show cause, in which you will explain, what it is that the order requires the contemptible party to do, and how that party is failing to do that. And the court will then notify that party that they must appear and present evidence to the court to show cause why they should not be held in contempt. In visitation type cases where a party is, for example, refusing to provide access to a child at the designated times, the court will most often in those kinds of cases, assuming that it finds the existence of contempt, will order makeup time. So instead of the father getting time with his child, on every other weekend, the court may order that for a certain number of weeks, visitation will occur on every weekend to sort of provide makeup time for missed visitations. And contempt cases based on failure to pay child support, which is, among the more common kinds of contempt cases that are filed, there are a variety of remedies that are available to the court, which get more and more serious as it becomes more and more likely that the party is deliberately refusing to pay child support. One of the things that parties who simply can't pay the child support will have to demonstrate, number one, why it is that they can't pay, if they've lost a job recently, whatever the case may be, and then that party should consider immediately seeking a modification order to reduce the amount of support that's actually payable. For a party who is looks like they're deliberately attempting to avoid paying child support, the sanctions can become more and more serious until eventually a party can be subjected to incarceration. So if you have a party in that situation, you're going to want to explain to them very early on that, to the extent they continue to refuse to comply with a court order to pay child support, they may find themselves incarcerated. And there are a variety of other enforcement mechanisms as well. They may lose their Maryland driver's license. Their tax refunds may be confiscated. So child support is one of those things where the court has a lot of different enforcement mechanisms available to it. In cases where the parties have minor children, you will very often have a circumstance that merits a request for modification of the court's either child support or child custody findings. That may be because the children grow older and the arrangement that had worked previously is no longer working. It may be because one parent wants to move out of the state. There are, all sorts of reasons why a modification may become necessary. In order to file for a modification of a court order, this is one of the reasons why you want to make sure you know when you talk to your client initially whether or not there are any existing orders. You must show that there has been a material change in circumstances since the entry of that order. So if it's been 3 weeks since the court entered its custody order, you're unlikely to be able to show that there's been a true material change in circumstances, although it's possible. I mean, it's certainly possible. But material change in circumstances typically means something like a party talking about moving out of state, a party who's no longer able to work for some reason. Maybe there's been some sort of medical issue that necessitates a recalculation of what child support is owed, something along those lines. Very briefly about bankruptcy. Generally speaking, the fact that a party files for bankruptcy before, during, or after a family law case will have not much effect on the court's proceedings, except in a couple of scenarios. If a court orders a party to pay certain kinds of things to the other party, such as child support, such as alimony, under bankruptcy law, those things will generally be considered something called a domestic support order, and those are essentially exempt from the bankruptcy process. A bankruptcy court will not tell a person with a DSO that they are relieved of their obligation to pay child support or alimony by virtue of filing for bankruptcy. Bankruptcy may become an issue where a party files for bankruptcy and there is a jointly owned marital home, which is either subject to foreclosure or which filing for bankruptcy may trigger a breach under the deed of trust. And I point all of these things out simply to make you aware that you should be keeping an eye out for bankruptcy issues in family law cases. And you may, from time to time, need to consult with experienced bankruptcy counsel to ensure that your client's rights are protected while the other party's bankruptcy is proceeding. The last thing I wanted to talk to you about was wage liens and orders. To the extent that the court orders the payment of child support obligations are enforceable by the entry of a wage withholding order. The statute requires certain language in the wage withholding order, so you will want to be familiar with that when you are preparing a draft withholding order for the court to approve. That order then goes to the other party's employer, and the employer is directed to withhold the sums that are payable for child support directly from that party's paycheck. I mean, that's about all I intended to cover today. Are there any questions?
Well, Jennifer, thank you. This has been very comprehensive. Anyone who has questions, please feel free to go ahead and put them into the box. If you'll type them in, we'll be able to review them now. So, Jennifer, I think you've taken a lot of information and shrunk it down. You made it sound so easy.
Yeah.
I'm not a family law attorney, so to make it being a tax attorney, it's really helpful to see this and to sort of understand the whole process. But I do admire those of you who are able to go through all this, because to me it's very complicated. So thank you very much. So let me just double check here. I don't see any questions at the moment. Another call for questions. If anyone has any questions, please feel free to enter them into the question box, if you could, not the chat box, but the question box. Thank you.
And if anybody thinks of something afterwards, you know, I mean, feel free to shoot me an email, and I'd be happy to shoot an email back.
Okay. Well, I think it was just such a complete presentation that everyone feels like they have learned quite a bit. So thank you. And again, these slides and the recording of the webinar will be available on our website, which is www.mvlslaw.org. It will be under that Attorney Resources tab, which is on the website. We again welcome everyone to join us in our volunteer panel if you are not already a volunteer and have an opportunity to put some of this knowledge to use. So thank you again, Jennifer. I think we will end at this point, and thank you so much for all of your time.
Well, thank you for having me.
For bringing us together. Thanks. Take care.
All right. Bye-bye.